If you're a veteran that's pursuing TDIU based on a protected work environment, then you should know that in January 2024, the U.S. Court of Appeals for Veterans Claims issued a decision that dramatically changed the definition of a protected work environment. In this video, we're going to go over the protected work environment exception for TDIU. We're going to discuss what the definition was prior to this case. And then we're going to talk about how this case changed the definition and how that might impact your claim for TDIU based on a protected work environment. My name is Greg. I'm an Air Force veteran turned lawyer, and I've been practicing VA disability law for over 10 years.
My name is Victoria. Thanks for joining us again. Like Greg said, today's video is all about protected work environments in relation to TDIU. So let's start with what a protected work environment is.
All right, so I'm bringing up 38 CFR 4.16a, which is the VA regulation that discusses individual unemployability, aka TDIU or IU. And I'm going to highlight the second half of this regulation because it talks about what a substantially gainful job is and what a protected work environment is. And so this first sentence that I'm highlighting states that marginal employment shall not be considered substantially gainful employment. And to get TDIU, you can't be substantially gainfully employed. And so what this sentence means is you can be marginally employed. And the next sentences go on to explain what that is. And most people are probably aware of this, but you'll see here it says that marginal employment generally shall be deemed to exist when a veteran's income does not exceed the federal poverty threshold for one person. And that's important. A lot of vets will say, I make $30,000 and the threshold for me and my wife and my 5 kids is 36, so I'm under the limit. That's not true. VA doesn't care the size of your household. Your income has to be below the poverty threshold for a single person.
What is the current poverty threshold?
For 2024, it's about $15,000 a year.
Okay, so $1,200-ish a month.
Correct.
And that is changed yearly.
Right.
Okay.
Yeah, every year that goes up with inflation. I guess theoretically it could go down if we have deflation.
So it's always judged off of the poverty threshold for a single person, regardless of family size. And it's insignificantly different year over year.
Yeah. I mean, it goes up by, $500 to $1,000 each year, usually. Okay. It's not a lot of money.
But for a lot of people who are working a part-time job where it's one day a week or a few hours a day, they can potentially still qualify for TDIU based on this definition and what they're bringing in. Potentially,
but it's important to keep in mind, VA doesn't care if you're working 1 hour a week, 5 hours a week, 60 hours a week. They define employment, substantially gainful employment, by how much you earn.
Okay.
So I'll get a question a lot. Well, I only work 5 hours a week. That's not full-time employment. VA doesn't care. All they care about, and this is because the VA disability program is designed to compensate people for loss of earnings due to their disability. All they care about is how much you make.
Let's move on to the protected work environment definition.
Yeah. So this next sentence that I highlighted is the definition as it was of a protected work environment. So it says marginal employment may also be held to exist where a veteran is engaged in employment in a protected environment, such as a family business or sheltered workshop, even where their earned annual income exceeds the poverty threshold. And so this is an exception to that income limit. If a vet's in a protected work environment and they're making more than the $15,000 per year, they can still get TDIU if they can show they're in a protected work environment.
Okay. And that's the full definition given?
Yeah. So this is the only definition, and it's really vague. They give an example of a family business. And so that's, a veteran works for his or her parents. And, your parents are never going to fire you, even though your work product is substandard. And if you were a normal employee, you probably would have gotten fired already. You're protected. You're in a family business. They're letting you work there because you're their son or daughter. So that's the classic example. But this is the entire definition. And there's been a tension between VA and the court, where the court has been telling VA that you need to give a better definition of what this is so that you, VA, can more consistently apply this regulation. And so that vets know when they qualify for it.
Right.
And this has been going on, I don't know, over 20 years now. The court keeps saying, VA, define it better. VA just ignores them, hasn't changed the definition. And so up until January, it was kind of Wild West, which honestly I liked. As an attorney, when something's not defined, you have more opportunities to argue.
Right.
It's not black and white. And so you can do persuasive argument that, hey, this is a protected environment. There's no bright line rules. Again, as lawyers, we like this definition because it gave us more room to maneuver when we're making our legal arguments.
Mm-hmm. This leads us to the new definition or clarification that was provided by the Labruzza case. What was the change that was made and clarification that was given? Yeah,
so in January 2024, Labruzza came out. If you want to look it up, this is the site up here. Just type that into Google. You'll be able to download it. But Mr. Labruzza was a Navy veteran, and he was appealing for TDIU, and the appeal period for TDIU covered a portion of time when he was still working. He attempted to argue that he qualified for the protected work environment exception because he said that he was given several accommodations that would have, otherwise caused him to lose his job. He was service connected for PTSD and residuals of prostate cancer. And so here you can see some of the things that he argued about why he was in a protected work environment. He had talked about leaving work early to avoid conflicts with his supervisor. I thought this one right here, that he had extended work absences of up to 2 months at a time. It's
a big accommodation.
Yeah. And so he had appealed for this. The Board of Veterans Appeals denied it. Basically, what the board said was that he was earning too much money. And if you're reading the decision, he was earning towards the end of his career. He stopped working in 2018. He was making almost $200,000 a year. Mm-hmm. His attorneys appealed the board's decision to the court and basically argued that the regulatory definition of protected work environment doesn't contain an income limit.
Right.
We just went over that. It's one sentence, and it says you can earn above the poverty threshold. It doesn't say that, you have to make below a certain amount. Mm-hmm. What the court ended up doing, I'm not really a fan of because now we have limits. There's more of a black and white definition of what a protected work environment is. And I think this case is going to make it harder to win these protected work environment cases.
Okay. What are the limits that were put in place because of this case?
There's basically 3 areas. I'll summarize those real quick. But the first one is that the veteran, for it to be a protected work environment, the veteran has to be shielded in some respect from competition in the employment market. And then the next one was that the court said the veteran had to be in a lower income position. And then finally, the court talked about the Americans with Disabilities Act and reasonable accommodations under the ADA. And so we can just go over each one of those.
Yeah, that's what I was going to say. Did they, with the first thing, the shielded from competition in a workplace, was there more description given about what that means?
Not much. The court basically said that a veteran has to be protected. Their job has to be protected from a competitive work environment. It's basically the employers are keeping the veteran employed, even though they're not the best employee.
Okay.
And so they didn't give much guidance on that.
Okay. I feel like that still is just so vague that it doesn't actually explain what that means.
Yeah. And I mean, you can see here in the decision, the court harped on this, that it has to be protected in some respect. It doesn't have to be completely shielded.
But did they explain? I mean, assuming that a regular person takes 2 months off without explanation or warning, that's not generally a tolerated absence from work. And in a lot of positions, employers wouldn't be able to navigate around that.
Yeah.
And so that makes me think in this circumstance, there was no competition if they were allowing 2-month absences.
Yeah. And he may win on that point. The court didn't deny his claim.
Okay.
They sent it back to the board to do a new analysis with their new definition of a protected work environment. So he may still end up winning on that point.
Okay. So there's more to come potentially on that.
Yeah. I mean, the board's going to issue a new decision that takes into account what the court outlined in this case.
Okay.
This is the definition right here. So using the dictionary, the court said they could surmise that employment in a protected environment was meant to refer to a working situation that is shielded, covered, or guarded from an outside source of harm. I don't even know what that means. I mean, an outside source of harm, I guess, would be someone taking your job because they're better at it and you're not good at it because the employer gives you all these accommodations.
Yeah. Or you're not available enough to complete your job
right
timely or appropriately. And if you're leaving early and you're gone for extended periods of time, and you're not getting fired, that seems protected to me, but
yeah,
I guess, like you said, that's still up for debate.
Yeah. I mean, I think missing work for 2-month chunks is a pretty big accommodation.
Yeah.
I'm not an ADA expert. I know people can take FMLA and not get fired.
That's
maybe it's just a regular ADA accommodation.
Okay, so let's move on to the second point, which is low income position or lower income position. For this point, did they set a limit of what it can't exceed, or did they give a number it needs to be below?
Yeah, so they gave a number that it needs to be below. They did hold that Mr. Labruzza's nearly $200,000 annual salary took him out of the running for being in a protected work environment.
Okay.
And their analysis is, again, the VA disability program is designed to compensate veterans for loss of earnings. And so if a vet is working and they're making well above poverty threshold, $200,000, then it's VA programs not designed to compensate those kind of veterans.
Right.
They clearly don't have a loss in earning capacity if they're making $200,000.
Right. And that's a significant income. But did they say, okay, our cutoff is 98,000?
No. So you'll see here in this sentence of the decision, the court's prevented from setting a bright line standard for what constitutes a lower income position. And so they didn't set, all we know from this case is that 200,000 and above is too much.
Okay.
But they did give indication that it should be much lower than 200,000. They have a footnote here, footnote number 7, if you look at this. And so this is the court, again, making suggestions to VA. We don't know if VA is going to do this or not, but it said, for example, to aid in making a lower income-based assessment for employment in a protected work environment, VA has reference to its maximum annual pension rate or income limits for VA healthcare purposes and other VA benefits that have income-based requirements.
Okay. Do you know what any of those numbers are?
Yeah, I mean, it all depends on the vet, and so there's different numbers, but it's generally around like $20,000 to $30,000.
Okay, so significantly lower.
Yeah, I'm just guessing because this hasn't been litigated yet, but I think 100,000 is probably out of the picture. I don't know where I'd feel comfortable arguing. Probably I'd say probably up to 50,000. So we still have a gray area. We don't know what that limit is. And so I'd definitely argue this. And, I would bring up the argument, I would, instead of looking at the federal poverty threshold for a single person, why not, if a vet's in a high cost of living state, let's use the poverty threshold in their state and also take into account, their family members.
Yeah.
There's no bright line rule.
Yeah, taking into account their family members, especially if it's a single family or single income family situation, if they are truly making this money because they're working for themselves or they're working for their family business and they're not employable somewhere else, then it doesn't seem appropriate that the number should be the same. That threshold should be the same. If the reality is they can't go out and get a different job, that they're allowed this job and they're allowed to earn this much because all of these accommodations are being made or these tolerances are higher. You know what I'm saying?
Yeah. I mean, I would argue all of that. It's still not set in stone. Again, the only thing we know is 200,000 is too much.
Okay.
So if you're below that, it's still worth trying. As always, the worst that can happen is VA says no.
All right. So let's move on to the third point.
Yeah. So the court kind of ended its discussion talking about the ADA and accommodations. And they said they agreed with Mr. Labruzza's arguments that a protected work environment takes into account accommodations.
Mm-hmm.
But they said, if a veteran's getting accommodations that are required by the ADA, that is not going to help them prove they're in a protected work environment, because that is the competitive work environment. The ADA is the law. Employers have to comply with that. So if they're just giving you what's required by law, they're not doing anything extra to protect you.
I mean, that makes sense to me.
Yeah. And so this is that sentence that sums that up. Employees who receive reasonable accommodations under the ADA are not being shielded from the competitive labor market.
Mm-hmm.
They are working within it under one of the conditions that govern it. And so then they go on to say, however, if it flows from that if a veteran is receiving accommodations above what's legally required by the ADA, that will help support their argument that they're in a protected work environment. This is going to require more technical legal work on, representative sides, because you're going to have to flesh out to the board, the ADA requires this, my veteran's employer is going above it and beyond that.
Mm-hmm.
And that supports that, he or she's employed in a protected work environment.
All right. Those are the three new clarifications. Obviously, some of it is still being looked at and may change. And if that's the case, then we'll do a follow-up video and talk about those changes. But overall, kind of summarize how this impacts TDIU cases going forward.
Yeah, I'm sure there's definitely going to be more litigation, more court cases on this, because like I said, over 20 years, VA has not listened to the court, and they won't provide any more solid definition of what a protected work environment. So I think the court's just frustrated and is like, fine, we're going to do it ourselves. And so, there's probably going to be a case where a vet's arguing that 100,000 is a low income position, and the court will issue a decision on that saying yes or no. So I think there's a lot more to come. The definition is still vague enough. And I mean, if you think you're in a protected work environment and you're making less than 200,000, you should try. There's no harm in trying. Thanks again for joining us. I hope this video is helpful. If you're pursuing a protected work environment TDIU case, or you're thinking of pursuing a protected work environment TDIU case. And as always, we're happy to talk with you. If you have questions, just schedule an appointment with us or shoot us an email, and we'll give you our thoughts on your case and if we can help at all.
Thanks for joining us. We'll see you in the next one.